AI and the courts. Hello, and welcome to the 39 Essex AI and the Law podcast. I'm Katherine Apps KC. In this episode, we're going to be discussing AI in the courts. My guest today is one of our new lateral hires to 39 Essex Chambers, Barrister Saara Idelbi. Saara and I have done cases together in this particular field, including one about anti-discrimination law, which was a challenge to an automated process within a UK government department. Saara also sits as a judge part-time in the Mental Health Tribunal, and also unusually for a barrister, Saara has also developed her own AI tool, or is currently doing so, which is going to be an advocacy training and cross-examination practice tool. Hello, Saara, and welcome to 39 Essex Chambers.
Thank you so much.
Artificial intelligence has been in the news quite a lot recently in United Kingdom courts, hasn't it?
Absolutely, and in many different guises, from intellectual property to freedom of information. Most critically for all lawyers in any space, two cases considered by the Divisional Court, Ayinde and London Borough of Hackney, and Al Haroon and Qatar National Bank. Those cases were considered under the court's Hamid jurisdiction, which, for any non-lawyers listening, it's the process where the court can consider whether lawyers are conducting themselves according to proper standards of behaviour, and if not, send them to their regulator, or in serious cases, consider that they have committed a contempt of court.
So what actually happened in the Ayinde case?
The Ayinde case was a homelessness judicial review, and there are many reasons why that case is an example of how not to do judicial review. But for our purposes, the grounds for judicial review were settled by very junior counsel, referring to several cases that did not exist. When challenged on the existence of those cases, no admissions were made. Indeed, by the time the case got to the Divisional Court, there had been no explicit acceptance that AI had been used to draft the grounds for that case. Then in Al Haroon, again, non-existent cases were cited, but this time in a commercial case, the lawyer's explanation was that it was his non-lawyer client who had found the cases and written the submissions. Understandably, the court was not happy with that explanation.
Yeah, I think these are probably not the only two cases actually in our courts over here in England. I've come across the issue of having fake cases cited to me when I've been sitting as an arbitrator recently. And of course, this doesn't only happen in the United Kingdom, does it? Is this sort of thing been coming up across the rest of the world?
Absolutely. And if you look at the appendix to the Ayinde judgment, it includes several examples all over the world where courts have been confronted with what has come to be known as hallucinated cases or hallucinations in the wider AI speak, and several further examples have been reported on since.
So just to help our listeners understand this, what exactly is a hallucination and why do they happen?
In essence, a hallucination in AI terms is the output generated by a large language model that contains misleading or false information presented as a fact. A large language model, or LLM, is a type of AI system, and there are many different types, that works with language and can recognize and generate text. What we hear about most when talking about AI are LLMs, such as ChatGPT, with GPT meaning generative pre-trained transformer. The clue about how it works is in the name, because the model is pre-trained on vast sets of data and is trained to recognize patterns across the data set, which means when you ask the model a question or give it a prompt, it will generate a response based on the patterns and context that it has seen across the data set that it had been given.
So essentially, it might come up with what it has seen before, or it might come up with something that essentially looks like it. Is that correct?
Indeed, the training of an LLM has no ability to qualitatively evaluate the data set it is trained on, nor pick out which pieces of the data in its set are more valuable or trustworthy. And this means that at this stage, it is a very sophisticated predictive machine for grammatically correct and plausible language, because it has such a huge number of data points. It doesn't have the ability to make qualitative judgments when responding to questions, nor does it have the ability to analyse or respond to novel issues or events. And that can create a mismatch between an LLM's response and the circumstances that were inputted into it. That inability is particularly problematic in the practice of law, because humans are remarkable in their ability to generate novel legal issues.
Yeah, lawyers coming up with new ideas. Who'd have imagined it? So essentially, the issue with LLMs, and particularly because it creates plausible language, is that the answer that you will get from a large language model will always sound really quite sure about itself, and it will look like the sorts of things that lawyers are used to seeing. So the ability to tell that it doesn't actually exist, you have to go back to the source material in order to check whether the case, for instance, exists. Now, some people talk about putting a question into something like ChatGPT or another LLM in a similar way to sort of putting a question into Google or other conventional search engines. But how are they different?
It will depend on the search engine, and we might come back to this, but in its raw form, a search engine is scanning for words. It used to be the case that website hosts would bury in the code the bits that you can't see, tags that would come up in searches. Google instituted a number of other metrics to decide which pages to display in response to searches done. By contrast with an LLM, and it will depend on whether you are accessing a free version of the tool or a paid version, but that is predicting what the answer is likely to be based on its previous training and acting through its transformer. So it's the equivalent of you asking me how to bake a cake versus going to a library and looking at the catalogue of baking books and then searching through those books and looking at the index to see how you can bake a particular type of cake. If you ask me, I might be right and be able to explain how to bake that cake. But if I don't know, I might just assume it's like baking bread and give you those steps instead. And you won't know which one I'm doing.
In some ways, though, things are a little bit closer than that, aren't they? Because some search engines also use AI or include an AI summary. So how does the use of large language models affect how we search through more conventional searching engines?
I'm sure we have now all seen the new AI summaries at the top of Google's search pages that you can't opt out of, and nudges to add AI to your browsers. There is a lot of discussion around the problems that arise from how far the internet is currently indexed for traditional searches when married with the retrieval augmented generation searches, which combines the traditional information retrieval system with generative LLMs. The way that Google, which remains the leading search engine, has maneuvered the internet to generate revenue, resulted in people packing pages with volumes of text to extend dwell time. So if you have ever looked for a recipe and found a painful diatribe about different kinds of wheat, really committing to the bread analogy here, and have had to find the button that says jump to recipe, that is one of the ways Google encouraged creators to drive their pages' visits. So that's now cannon fodder for generative AI prediction because it gets rolled into the search results with the effect that what we get out is mediocre quality output because the priority is speed and response over the quality of response, and lots of what is read and trained on in publicly accessible materials are adverts, Reddit threads, anything. You have the added problem now that LLMs are trained to want to give you an answer. Nil returns are not an option. Whereas with old school searches, if there was nothing, you could kind of see the closest alternative, and that was clearly delineated for you. So given that I am a lawyer, not an engineer at the moment, why does that all matter? Well, it means that lawyers have to be cautious when using AI in searches. Free tools are closed systems. So if the material in the LLM is trained on material that did not include cases, it won't be able to access new cases or sites that would publish fresh cases as they are handed down. Many case sites have restrictions on LLMs accessing their sites for information. So, for instance, I think Bailey has restrictions on it, so LLMs can't scrape information from that site.
We also have to be careful as lawyers, don't we, in terms of our own clients' data and the documents that we create, that's not being scraped for future versions of generative AI. I suppose that the core issue that you're describing there is that the response given by something like ChatGPT or a large language model is not capable of making a qualitative distinction between, for instance, a judgment of Lord Bingham and a Reddit thread. They will both be texts that it will have incorporated, and either one might come up without you necessarily knowing which. Isn't there also an issue issue about the amount of content that is actually increasingly available on the internet. A lot of that is increasingly LLM generated itself. So that's creating sort of more and more volume for search engines or for whatever searches that people are doing to have to wade through. And that is potentially making searches less accurate rather than more accurate because of the large amount of generated information that is then in the public domain.
Absolutely. And I think that's come to be known as the slop problem. And the failure to know how AI can adversely affect your legal research can lead you into serious error. So it's time for lawyers to understand that the technology works this way and how it impacts on our work has to be taken into account. Actually, an example today, I was researching an area of law and the returns I got I could see was based on provisions in a statute that hadn't been brought into force, which could very easily lead you down the wrong path if you haven't picked up how it's come to that conclusion. So it's particularly important now, given what was said by the Divisional Court in Ayinde.
So just turning now to that, what did Lady Justice Sharp say in Ayinde that all lawyers have to do when we're looking at materials and considering what we ought to be doing in this modern world?
A great place to start for the summary is paragraph 9 of the judgment. And she says that there are serious implications for the administration of justice and public confidence in the justice system if artificial intelligence is misused. In those circumstances, practical and effective measures must now be taken by those within the legal profession with individual leadership responsibilities, such as heads of chambers and managing partners, and by those with the responsibility for regulating the provision of legal services. Those measures must ensure that every individual currently providing legal services within this jurisdiction, whenever and wherever they were qualified to do so, understands and complies with their professional and ethical obligations and their duties to the court if using artificial intelligence. For the future, in hammered hearings such as these, the profession can expect the court to inquire whether those leadership responsibilities have been fulfilled.
Yeah, it's a pretty hard-hitting paragraph, isn't it? And I know we here at 39 Essex, I did some training to all staff and all members of chambers in artificial intelligence. I'm sure other barristers' chambers, law firms are doing the same thing. There's guidance, isn't there, published by the Bar Standards Board here in England and Wales and for the solicitors' profession as well. Has the judiciary published anything else in relation to use of AI that we should be aware of?
Yeah, so the judiciary published guidance some time ago and it has been updated in April of this year. We also have more and more guidance coming out of various professional bodies, and internationally you are seeing proceedings that are arbitrations or otherwise also issuing guidance on how to use AI.
In that paragraph that you just read out there from Lady Justice Sharp, that phrase of if a lawyer is if using artificial intelligence, that phrase if using is carrying quite a lot of weight there, isn't it? And people might just assume that the way they get around this is just by not using ChatGPT to search for cases, but it goes a bit deeper than that, doesn't it?
Yes, and it obviously also comes down to what people consider the use of AI really looks like and is. And as we've already discussed, that kind of slop problem, being able to filter out what is material that has been AI generated itself, it just makes search engines much more difficult to find information because all of that data is not treated equally.
I think the essential point for lawyers is that you may well be using AI if you are searching on Westlaw, Lexis, Bailey, Google, all of the usual tools that we use. Some of what may have been gone through to answer those searches might be AI generated material. The other issue we haven't talked about yet is this issue about augmented searches, that sometimes search engines will ask the question that they think that you meant as well as the question that you've put in. And sometimes in legal proceedings, we have to explain what it is that we've done, don't we? And what searches we have done. So we have to be very alive to the fact that we might actually have done additional searches to the ones that we've put in and making a record of that. So, Saara, there's also the issue of personalisation, isn't there? Lots of the marketing around AI often says that this is one of the benefits of AI, that the results can be hyper-personalised to the individual. So how exactly does that work? And is that an issue for lawyers?
It is an issue for lawyers Personalization of search results is a feature that tailors search engine results to the individual's unique preferences, interests, and past behavior. So, for instance, if you visit a website frequently, like Bailey, your search engine results may prioritize information from that site for you. You might have also accepted cookies of another site you haven't visited from a site that you have, which may then prioritize information from the site that you hadn't visited in your search results. The introduction of AI into that process and what you get is personalized in that it is said to be even better at understanding the user's intent when searching to pull out the relevant results for them. The problems for the practice of law ought to jump out at you. If you are a layperson that never looks at case law websites or legal pages, or are very new to practice as a lawyer, then your search results is pretty likely to be quite different to what I will get if I was conducting the exact same search. If your legal practice is intersectional, which often our cases are, and I'm researching a different area of law, then my results may be different from a lawyer whose practice is solely in that area of law. Going back to your point about the phrase on using AI in Ayinde, we know that this is becoming a standardized feature of many search engines. That means that at the user interface, you may not see that AI has personalized your search results, and you can't assume that the immediate search return is the complete and accurate picture.
Indeed, we actually ran a practical sort of test on this when I was running the session on AI for Chambers. One of the clerks and I ran exactly the same search string into Google, essentially asking about UK cases about the use of AI. And on my search results, well, actually, both the clerk and I got the same search results when we were in Chambers, but we also tried at home. Now, in my search results, the Bar Standards Board guidance came really very high up the list of results. When my clerk checked from home, but also when my husband, who's not a lawyer, checked, you could find the BASB guidance, but you had to go much, much further down the page. And this is an important point for judges also to know, that what a litigant in person will get when they search on Google for law might well not be what the judge gets. Now, this personalisation issue, it's also an issue when lawyers and judges are using AI to produce summaries, isn't it, Saara? That personalisation might then be expressed in the results that come out. Can you just explain how that might happen in practice? And, are there any practical examples?
We have a recent practical example from the tax chamber of the first tier tribunal that had a decision published at the end of August, where the judge explicitly confirmed in his decision that he had used AI in the preparation of the decision. It was a case management decision, and the judge explicitly stated that it was dealt with on the papers. He'd not heard any evidence. He wasn't called on to make a decision about the witnesses' credibility or honesty. But he had said that he used AI to summarize the documents, but then went on to satisfy himself that those summaries were accurate. It's important that one does confirm that the summaries that you get are accurate because, as we've discussed earlier, AI cannot make a qualitative judgment about what in a document is relevant. So as an example for myself, I often use AI summaries to do a first pass on a decision, on a handed down judgment, before I then go in to read the judgment. And I've seen times where the summary will refer to a part of the factual background or a part of the submissions of counsel as being a part of the decision. We've got to be alive to the fact that AI might pick out the wrong part and present it to you as though that is the important bit.
Indeed, Saara, and I think when you and I have been discussing this before, you've used the word that sometimes AI seems to be sycophantic, doesn't it? It sort of tells you what it thinks that you want to hear, which as a lawyer isn't necessarily really what you want to hear. You want to find the relevant part of the document. And of course, what the relevant part and what the relevant information is will depend on what question you're actually looking for in the document. What are you really looking for? And it might not be the same thing that you were looking for last time that you looked at a document. You're obviously using AI in the context of the platform that you're trying to develop as an advocacy training tool. Do you have any stories from that are particularly helpful for us in understanding the nature of the issue?
Yes, it's been interesting. We started with trying to train the model, which we'll discuss in a little bit more detail, but we have a standardized starting question about how to become a barrister. And the very first time we put it through what it had been trained on, it gave us the answer of, you have to perform puppet shows, which at present has been entirely alien to my practice. So that wasn't a real surprise. It also at times tries to correct aspects of the code and what we want to say in our platform, which is frustrating and problematic. So one of the real focuses that we have is making sure that we're developing a bit of a pessimist, but our tool, Advocator, is an advocacy training platform for lawyers to practice their skills rather than take anything from it and then regurgitate it or put it into skeleton arguments that might eventually be used in court. So AI does have some opportunities to help us expand our skills, improve our practice. But in order to use it, we also have to be alive to the risks and the benefits and how those risks and benefits are going to change over time.
So essentially what you're developing is a way of lawyers sort of trying out lines of cross-examination or practicing their skills without having to practice it on real live clients and real live cases, so that they can kind of upskill in that safe way before being let loose on the general public.
Yeah, that's our aim at the moment. And the initial offering, we're going through a more traditional, having preset exercises, getting people to get feedback on their submissions and having that feedback being AI generated. But eventually we'll hope it's going to be interactive.
Oh, that sounds very interesting. So it's not necessarily all gloom in the world of using AI in law, but we just have to be careful as to understanding what the nature is of the thing that it is that we're using, really. Is there anything else positive that can be said that's not quite so gloomy about this particular area?
So some of the AI searches that you can carry out on specialist legal databases can be better than open searches on Google or search engines that then regurgitate an AI summary back to you. And in my experience so far, for the moments where you can remember a case or principles of a case, but you can't put your finger on the name of it or the citation, it can give you a real boost to understand the thread or find it again. It can also be useful if you're completely new to an area of law to start the thread for your research, but it shouldn't ever be considered the end point.
We just have to be careful about what it is that's being boosted in what way, and it's really the right tool to be doing the particular boosting. Now, in the litigation that you and I, we've both been involved in together, one of the challenges can be actually explaining to a court in terms that can be understood by the court how a complex technological process actually works, particularly in terms of the data that it's processing. Is that going to be increasingly an issue with either lawyers using AI or clients using AI within their own operations?
I think so. You can still get those issues of inability to explain what's happening with current technological systems that use automated or semi-automated processes, whether they're AI or not. It's just very difficult to disaggregate what's happening. And I think that when we see the enthusiastic proliferation of LLMs and AI as been promised by different sectors of government, we are going to find it more difficult to deal with judicial reviews that require the government to explain how certain decisions or processes came to exist.
And I suppose that there is the sort of technological foundational difference that even though it might be complicated in, say, an automated or semi-automated system, it is still possible, albeit often quite difficult to understand. It is in theory possible to explain what the input is and what that input, if it has a particular answer to it, what that then changes in terms of the back end of the software or whatever it is, and what then that triggers for the next stage. Whereas within generative AI models, there is that opacity, isn't there, inherently, and also sort of non-identical paths that might well be happening without there being any ability intrinsically, because of the technology that's being used, to explain what exactly has happened, on what basis has the particular output been created, and is it reproducible the next time round with exactly the same inputs.
Yes, and it leaves everything really uncertain for understanding how we are now delivering services to individuals. We are obviously at the beginning part of the training of the LLMs, and we don't know whether or not in future models will feed into other models. And so then you get this compounding effect of not understanding the underlying data set that ended up in the one that is being used to face the public.
Yeah, so we definitely have challenges in future, certainly in this area. In this series, David Mitchell, who's my co-presenter, and we ask all of our guests the same question at the end of the episode. And it's a scale question on a scale of 0 to 10, with 10 being the most positive and 0 being the most negative, about how you feel about the use of AI in the future. And given that you wear two hats, both your technological hat and your lawyer hat, if I can ask you to wear both of them in answering this question, that would be really great.
So through the lens of how I use and hope to use AI and what we're developing at Advocator, I think I'm probably an 8. But as a lawyer, I am a pathetic fence sitter and sit at about a 5. I guess I'm as positive about AI as humankind might have been when it first discovered it could make fire.
So, Saara, that's pretty positive when you come to sort of you as not as a lawyer, but it's interesting. I think you're the first person who's been more pessimistic with your lawyer hat on than with your human hat on. But that's why it's an interesting question, I guess, to ask. But thank you so much, Saara. That was absolutely fascinating. And we're so delighted you joined us here at 39 Essex Chambers. And also thank you very much for listening to this episode. I'm Katherine Apps KC, and you've been listening to the 39 Essex AI and the Law podcast series. If you've got any other ideas for future episodes, feel free to drop us a line. All of the details are on 39essex.com. This episode was on AI and the courts. Thank you very much for listening, and goodbye.